The First Amendment states in absolute terms that Congress shall make no law abridging the freedom of speech or of the press. These provisions have been incorporated to the states as well. However, there are circumstances where limiting the freedom of speech of expression is justifiable.
Speech can be limited by time, place, or manner. Restrictions, as long as these are considered neutral, narrowly defined, serve an important government interest, and leave other options of speech open. For instance, in Ward versus Rock Against Racism, the Supreme Court stated that the city of New York could control the volume of a late-night concert in Central Park.
The content of expression can also be regulated in some cases. The court has determined that the government can limit obscene speech, seen in Miller versus California, defamatory speech, seen in the New York Times versus Sullivan, fighting words, seen in Chaplinsky versus New Hampshire, speech that incites unlawful actions, seen in Schneck versus United States, child pornography, seen in New York versus Ferber, and true threats, seen in Virginia versus Black.
Some types of speech are subject to more restrictions than others. For instance, advertising and commercial speech can be limited to protect consumers. Speech in schools, prisons, and military bases can be restricted when it interferes with the purpose of the facility.
We agree with the court that expression can be limited when it threatens another person's safety or seriously harms the society as a whole. However, any restriction on freedom of expression must meet certain standards in order to be justified. When limiting speech, the government must have a significant and compelling interest to protect, and law must be the least restrictive way of achieving this interest. We would also demand that restriction be narrowly defined and clearly stated.
We also think that the different standards should be used considering different mediums and circumstances. Different standards like the Miller test of obscenity can be tailored to a specific type of speech, which makes them clearer and easier to use.
This is why we should support a separate standard for hate speech, which will allow legislatures to limit it. The courts have decided that hate speech can only be restricted when it leads to immediate hate violence, and thus constitutes fighting words. In RAV versus the city of St. Paul, the court struck down a statute that prohibited certain symbols associated with hateful expression because it was the equivalent of thought control. We disagree with the court and propose that speech should be restricted when it meets the following criteria. It vilifies a person or a group on the basis of one of more numerous characteristics, such as race, sexual orientation, gender identity, religion, or disability, and it is done with the intent to intimidate or it leads to immediate hate violence.
However, we want to acknowledge that freedom of expression, unpopular or controversial ideas is important and should be protected. Hate speech done with the intent to intimidate is a narrowly defined type of expression that we think should be limited. Other controversial speech should be protected because it brings benefits to both the individual and society.
Freedom of expression promotes individual growth and gives individuals a chance to have their ideas heard and considered. It benefits society by allowing people to challenge their government and each other through dialogue, not violence. It advances knowledge by creating a marketplace of ideas. As philosopher John Stuart Mill said, progress is possibly only when all points of view can be expressed.
This does not mean that the freedom of expression has no cost. As we have seen most recently in Snyder versus Phelps, sometimes the views that people express can be hurtful to others. When we protect the freedom of expression, we also open the door to offense and emotional distress. However, the benefits of freedom of expression far outweigh these negatives. As Justice Roberts stated in the decision in Snyder, we cannot react to Snyder's pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues to ensure that we do not stifle public debate.
Occasionally, fundamental rights can come into conflict. Do you feel like it's a denial of freedom of expression for courts to issue gag orders in infamous criminal cases wherein the defendant and his counsel, the prosecution counsel, and even the press can be prohibited from publishing details with regard to the trial? Is that a denial of freedom of expression? Yes. If courts issue gag orders with regard to a pending criminal trial, is that a denial of freedom of the press or the individual rights of the participants to speak?
I don't think that it is like an infringement on the First Amendment because I don't think it's an infringement on their First Amendment rights because,
Let me go to a different
Can you go-
question.
can you
Let me
go-
go to a different question. If you have the right to speak, you have not the right not to speak, as in the Pledge of Allegiance.
I think that you do have the right not to speak to for the Pledge of Allegiance, and you can see that the President's Pledge of Allegiance isn't required in schools anymore because not everybody may, have that same feeling of nationality for the country. And I think it's okay that some people can choose not to speak when they want to, because on the opposite side of being able to speak when you want to, being able to express yourself and express ideas.
Thank you.
You talked about some of the restrictions on freedom of speech. One of those restrictions is national security. And we've seen recently with the tragedy in Boston that a lot of the information that these young men were getting was from the internet. Do you think that if the U.S. government decided to restrict access to that type of information on the internet, do you think that that would be appropriate as a national security matter, or do you think not?
I definitely think, and protection-wise, that definitely should be more censored and contained to the protection of America. Although we do have a lot of access to a lot of things as far as knowledge purposes and for like a project, for instance, like research, studies, it does affect us so that, and it does kind of censor the access that we as people have to our government to know what's going on around us. But as far as protection is more important to us than anything. So I think that should be considered a protection, so yes.
Jasmine?
Yes, I don't like to agree, but yeah, disagree because I think it all depends on what's going on in that society. Like if you see something on the internet and it looks wrong, then it should be like, hold on, like let me look at this, let's check this out some more. Then the protection should be.
I think it draws a connection in terms where speech is more restricted during war times, and like in terms of like national crises or terrorist attacks, that speech should be restricted more to protect people.
Let's take Boston one step farther, maybe make it within your world. You live in a world of social media with internet and Twitter and all those things. Much of the early reports out of Boston were just that. They got the news quicker than we've gotten news before. So Boston's a very teachable example of the Constitution, in action. Do you feel there should be, based on what you just said, though, should there be some restrictions on the social media aspect based on what you've just seen in Boston, or based on, in general, what some of the issues you've seen where schools have had to step in and close down accounts and things like that?
I think it should, but I don't think it should be like restrictions where it scare people because like this as in 9/11, it scared everybody. So everybody was on the lookout. Like, wait, he's doing this, he's doing that. So I think it was tragedy in Boston, but I think that the restrictions should be within like the people who's doing it. Like they found us two guys, they should be looking into what they're doing and like the friends that they know. I don't think it should be within the whole everybody to scare people, because then it'll make it worse.
To add on to what Macaulay Johnson, I absolutely agree with her. It should not be restricted within the whole, because not the whole are out to do things intentionally or put the world into danger. Some just want to know about what's going on around them. Some want to know what's going on in their government. And I think the social media, when, for instance, you said it was put out more in the Boston case, I think that informs us more what's going on around us, because nowadays, my peers, all our information comes from the internet, social media, so that's a way to inform of us and to know what's going on around us.
I disagree with my two colleagues, and I say that because in times of crisis, it's like the Boston event, I think that like social media especially should be more restricted, because you never know what information is true and what information is not true. You could be getting false information through word of mouth that may not even be true. Like, for example, for the Boston incident, people could have said like certain persons detonated the bombs, and they could be completely wrong. And it wasn't like a statement released by the government, or it wasn't on the news. It was like on the social media. So you may not always be able to take people's words with truth.
That's okay. Nice.